Welcome to another gripping day inside a Michigan courtroom. Today we follow multiple defendants, multiple charges, and multiple surprises. From domestic violence allegations to probation violations, from plea deals to emotional bond requests, this docket is packed. We open with Destiny Cheetum, appearing remotely with a shattered screen and a waived preliminary examination, followed by Sean ODM's tangled history of bond violations and violent accusations. Add in a law student's courtroom debut, a plea to resisting arrest, and a defendant begging for a second chance to keep his job, and we've got everything: drama, law, and life-changing stakes. Stay tuned because things are about to get intense.
Court does call the case. People, State of Michigan versus Destiny Cheetum.
Good morning, Your Honor. Marie Cameron, Assistant Attorney on behalf of the people.
Good morning, Rep. Jacob on behalf of Destiny Cheetum, who's on Zoom, and we appreciate allowing her to be on Zoom. Destiny, would you state your name for the record, please?
Destiny Cheetum.
Okay,
Do you have a camera, Destiny?
No.
Let's talk courtroom etiquette and technology. While virtual appearances are now standard, showing up without a camera, even for valid reasons, can raise eyebrows. Judges want transparency literally and figuratively, but here the court accepts Destiny's explanation and proceeds. What do you think? Should a broken screen be enough to waive visual presence, or does it risk undermining the gravity of court proceedings?
Cheetum,
Yes.
you understand that you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing today and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yeah.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Judge, we acknowledge the information waive its reading. My client would stand mute.
Defendant having waived formal reading, standing mute.
This is a pivotal moment. By waiving her preliminary exam, Destiny essentially skips a crucial step where the prosecution must show probable cause. It's a strategic move, often done in exchange for plea negotiations or simply to avoid more court delays. But it's a gamble. Would you waive that right if you were in her shoes?
Continue in this matter.
Thank you, Your Honor.
Court does call the case. People versus Sean Odom.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Good morning to your honorable staff. If you please, this court, Brandon Bird, PA 3734, on behalf of Sean Odom. Mr. Odom, can you please state your full name for the record?
Sean Martell Odom.
Thank you.
You up?
If you're today's the date and time set for the preliminary examination. At this time, the people are unable to proceed as to count one, and would ask that count two in the added count.
Amended complaints often signal that the prosecution has reassessed its evidence or found new allegations. For Sean ODM, the addition of a domestic violence second offense ramps up the stakes significantly. Remember, second offenses come with harsher penalties. When charges evolve mid-case, it can catch the defense off guard. Think this was a fair move or a pressure tactic?
You need a copy of it?
Right, I never seen the amended complaint, Your Honor.
Did you want me to pass it so you can go over that with your client?
Yeah, let me please.
Okay.
Your Honor.
So I'll pass the matter. We'll take him back, then you can go run and talk to your client. Call it back up. Court does recall the case. People versus Sean Odom.
And then on behalf of the people, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Sean Odom. Mr. Odom, can you state your name for the record again?
Sean Martell Odom.
Thank you.
You up?
All right.
Yes, Your Honor. We did get a chance to discuss this with my client. Understandable. We're gonna waive the formal reading, stand mute.
All right. Court will enter not guilty plea as to that count three. Maintain his plea of not guilty as to count two. Count one will be dismissed. I'll set a pretrial on counts 2 and 3 for May 28, 2025, 9 a.m. That is Judge Perry at the 15th District Court on the misdemeanor charges. All right.
Permission to address bond, Your Honor.
Figured you would. Go ahead.
Respectfully, we got the misdemeanor that was dropped today. It's the same complaining witness that's on this case. That's just been dropped at the second. So I'm not sure really how far this case is gonna go, but that's something we'll see in district court. Essentially, my client has been in jail for
Now here's the heart of the debate: freedom versus accountability. Sean ODM's defense paints a picture of a man who's already served time for misdemeanors while awaiting trial. But is that argument strong enough when there's a history of assault and ignored bond conditions? The judge has a tough call: balance time served with public safety. What would you decide?
or
You got
it's almost like it's almost like he'd be serving a sentence if he stays in jail too much longer. One of these is a 93-day misdemeanor. I understand the other one's up to a year. But respectfully, we're gonna ask for a personal bond in this matter. He understands no contact with the complaining witness. He doesn't want any contact with the complaining witness. My client doesn't want to be sitting in the jail cell like
Well,
he is right now.
he had a personal and then messed that up.
Understandable, Your Honor, but now we're dealing with a whole new set of situations in which my client's been sitting in jail for a month now, almost a month. And I'm pretty sure a month in jail gives you a lot of time to think about where you want to be and where you don't want to be, and how you operate.
Answer the people. I want to go back to work.
Severe concerns that he can.
This one hits hard. The prosecutor lays out chilling allegations, not just contact violations, but new assaults and a child with a black eye. These aren't just procedural failures, they raise serious concerns about ongoing danger. Bond isn't just about showing up to court, it's about proving you can stay out of trouble. Is Sean ODM a victim of overreach, or does his record speak for itself?
In contact with her, and I have great concerns for her safety and her child's, given the facts of this case and his previous history with numerous dismissed DVs and convictions on DV.
Anything else, Counsel?
Respectfully, Your Honor, my client went to the police station. He went to the police station and made a police report in Ann Arbor, in Ann Arbor. That's one of the reasons for the contact.
So right, but here's what ended up happening. He had a personal bond. He didn't follow the conditions. He then came into custody.
The judge draws the line. Despite emotional pleas and mitigation attempts, the facts, missed conditions, continued contact, and new assaults speak louder. The judge makes clear second chances mean nothing if you blow the first one. What's your take? Harsh but fair, or should the court have shown more leniency?
Other stuff that the prosecutors indicated regarding the other contacts and other complaints that he has with the victim in the case. What I'm going to do is I'm going to deny your request to reduce his bond. You can take it up with Judge Perry, but at this point, I'll do it that way.
Thank you for hearing me out, Your Honor.
Court called case People versus Jalen Kendrick.
Ally Zend on behalf of the people, Your Honor.
Oh, boy. Oh, no.
Good morning, Your Honor. Student Attorney Kara Rosengren requesting to practice under Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Hannah Apple on behalf of Mr. Kendrick. Could you say your name?
Jalen Kendrick.
So where are you from?
Me?
I know where he's from. I got all that information. I know where Apple's from. Yeah, you.
I attend Cooley Law School, Your Honor.
You do?
Yes.
Oh, a Michigander or you?
Yes.
What part?
I currently reside in Dexter, Your Honor.
So even a Washtenaw County, Michigan.
Yes, Your Honor.
Where are you originally from?
Oakland County, Holly, Michigan.
Yeah, kind of blew it there. Okay. Where'd you go to undergrad?
Western Michigan.
So you just never left the state?
I actually lived in Chicago for 15 years, Your Honor, so.
Did you?
Mhm.
Didn't like it?
Loved it, but came back for my husband's job.
Oh, he's to blame. All right.
A moment of levity and growth, student attorney Kara Rosen gets permission to practice under Michigan Court Rule 8.120. For aspiring lawyers, this is a big deal. It's also a reminder while some lives unravel in court, others are just beginning. The judge even jokes about her Michigan roots. Ever wonder what it feels like to make your first argument in court? Welcome to the deep end.
Defendant's not guilty plea as to count 2. Pretrial in this matter will then be set for
For Judge Washington.
June 9th, 2025, 9 a.m. That is before Judge Washington. Thank you.
Thank you.
Bond will continue. Thank you. Court does call the case People versus Quinard Sanders.
Good morning, Your Honor. Alex Warren, Green on behalf of Mr. Sanders. State your name.
Quinard Sanders. I have a plea form in front of me.
Correct, Your Honor. We are going to be proceeding on a guilty plea. Mr. Sanders is currently executing a sentencing judge waiver and the advice of rights form for the court.
All right. Plea form indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing a 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. There's further the agreement of no delayed or deferred sentencing. That's the court's full understanding of the agreement.
That's our understanding, Your Honor.
Is that correct, counsel? All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the true self you got? State your name.
Woodard Sanders.
All right, sir, it is this court's understanding that you are going to be pleading guilty to.
This is what taking responsibility looks like. Sanders admits he ran from the police and affirms that he understood the officer's lawful authority. The judge walks him through every step: rights waived, plea entered, sentencing set, no surprises, no drama, just a defendant accepting his fate. Some might say it's rare these days. What do you think? Wise move or missed opportunity to fight back?
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
Nope.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Well,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no, Your Honor.
Sorry.
No.
Has anybody threatened you or forced?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of December 17, 2024, at the location 500 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you come into contact with a police officer from the Ypsilanti Police Department?
Yes, Your Honor.
What happened?
He asked me to get in the car and I ran.
I'm sorry?
He asked me to get in the car and I ran.
May I have what do, Your Honor?
Pardon?
Ma'am,
Yeah,
what-
go ahead.
Mr. Sanders, you were approached by a uniformed officer on that date at that location, right?
Yes.
And that officer informed you that he was investigating a crime, right?
Yeah.
And you began walking away, right?
Yep.
And he told you to stop.
Yep.
And you ran.
Yes.
Okay. You knew he was a police officer, right?
Yes.
You don't dispute that he was acting pursuant to his lawful duties, do you?
Nope.
All right. Your Honor, I believe that lays a factual basis.
As the court complied with the court rule, would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing will be
May 28th at 10 a.m.
May 28, 2025, 10 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Chambers. Court does call the case of the People versus Stephen Watson.
We're ready in this matter, Your Honor.
Good morning, Your Honor. Katie Rispersky.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Stephen Watson. Mr. Watson, please state your name for the.
Stephen Watson.
All right. What are we doing?
Your Honor, as the court is aware, this is time and place scheduled for preliminary examination. People are able to proceed this morning. I would anticipate a motion to dismiss the felony. I would be seeking a remand on misdemeanor, but I seek the court's guidance as well. It's charged as a DD first, and it should be a DD second. I apologize to the court and counsel that I do not have a DD complaint prepared, but I could move to add a count 3 of DD second or amend count 2, whatever the court's preference is.
Oh. And Ms. Zenda is like an expert
I mean,
at getting those amended complaints done. And so I think Ms. Zenda might help you out
I
there.
think she's doing the things right now.
Oh, is she? Okay, see? So what I will do then is, and should we do that? I mean, it's my case, so I'll remember, but should we do that as a count 3 or just amending count 2?
Just amend.
Count 2, you think will work? Okay. So we'll just amend count 2 to reflect it.
A dropped felony might sound like a win, but Stephen Watson's troubles aren't over. The defense argues for a bond reduction citing work and lessons learned, but the judge isn't sold. Missed drug tests, skipped appointments, it's a familiar pattern. In court, consistency counts. Is this a man trying to change or just another excuse?
In this matter, DB second. Count one would be dismissed as people are unable to proceed. I'll set a pretrial in this matter for
May 19th at 1 p.m.
May 19th, 2025, 1 p.m. That's before me.
Thank you, Your Honor. May we address the issue of bond?
Sure.
Honor, my client was out. He had difficulty and I believe there were issues with
Positive drops.
positive testing. My client does have employment. He is hoping that the job is maintained for him, but he does not think it will be maintained for too much longer past today's date. The felony charge was dismissed because there is no complaining witness. I expect there will probably not be a complaining witness at the court date as well. Based on that, Your Honor, I'd ask that my client's bond be returned to its previous state. My client has indicated that he will follow all of the strictures of the court. He has learned the importance of not indulging in drug use during any time period. He's asking that he be allowed to have his bond reinstated. The time he has sat in has taught him a valuable lesson.
The problem is that he was testing positive. That's part of the problem. The other part of the problem is he was supposed to then start CCOP and he didn't appear.
I talked to the agent and working a lot of hours. Told me to come to court and signed up for the COP or whatever, because I can do intensive outpatient treatment.
So, Your Honor, he did have contact. The problem was at the time he was working a lot of hours and he had gone past the time when he should have been reporting. He did speak to the agent. Agent told him to come to court and then he could start getting into the program then. It's not that he doesn't want to. It's not that he intentionally tried to avoid what needs to be done. He set priorities with working and maintaining himself and his family. And that priority, as it turns out, was the incorrect. He has learned then what the priority should be. And again, it's not like he didn't make contact at all. He did do that. He was working. He'd like to continue to maintain that employment.
Okay, I don't need a response from the people. I'm gonna, at this moment, deny your request. I'll look at it again come the 19th. Since it's coming back before me, it's just less than 6 days from now. I'll take a look at it. I would like to see something that's gonna keep him on track, because if he continues to use, doesn't do anything, we're gonna be right back in the same boat. So
I'm not going to use. My job is at risk, and I'm for positive drops, and I can guarantee that. I'm just trying to get back to work. My job is.
no, I hear you.
Yeah, Judge Simpson.
But
I really learned my lesson. I understand the importance of not dropping dirty and things like that, and I have learned my lesson. I don't need to be in here. If you give me a chance, I won't let you down. I'm really just trying to get back to work. And
how many times do you think I hear that?
a lot, Your Honor, a lot. And
So tell me what makes you different.
Because I got 6 kids. I got a lot of things going on, and I'm not a person that constantly gets in trouble. I'm done with the drug use. My system is clean, so you have no problems with that. So if I drop today, drop next week before I come to court, everything could come back the same. And you got my word on that.
This moment's powerful. The judge asks, how many times do you think I hear that? The defendant pleads for trust, promises he's changed. The judge has heard it all before and she's skeptical. With 6 kids and a job on the line, he swears he's ready to clean up. But talk is cheap in court. What would convince you he means it this time?
I come back and plead guilty to everything. I'm just really trying to get back to work. And you won't have no problems out of me
I
after
think you
today.
need to get yourself set up with some type of outpatient.
Yeah, and that's what I'm saying. If I go to community corrections today, I can sign up for the intensive outpatient treatment. So I can be able to get on the right track, but there will
I'll
be.
tell you what, I'm gonna at this moment deny your request. However, if council would contact community corrections, see what they need, I will consider an order to release him with some strict compliance in their program.
Corrections, see if they have something in place for you.
Okay.
Oh, yeah.
Please.
So I'm not saying no forever, but I'm gonna need something that,
Thank you, Your Honor.
thank you.
So,
Thank you, Judge.
Okay. Court calls the case, People versus Timothy Stevens.
Alexander, on behalf of the people, Your Honor.
Oh, you're back.
Student Attorney Kara Rosengren, on behalf of Mr. Stevens, Your Honor. State your name.
She's back.
Stevens.
Your name, sir?
Timothy Stevens.
Thank you.
In your understanding concept of preliminary examination, at this time, the people are unable to proceed as to counts 1 and 2, as that count 3 be remanded to district court.
So you're moving to dismiss counts 1 and 2?
Yes, Your Honor.
Counts 1 and 2 are dismissed. I'll maintain the defendant's not guilty plea as to count 3. Set a pretrial in this matter for
June 5th, before Judge Rush Hour.
June 10th, you said? 5th, 2025, 10 a.m. I'm sorry. 10 a.m. before Judge Fresh Hour.
Thank you.
Yeah, continue.
Thank you.
Thank you. Court does call the case, People versus Deborah Gilmore.
Katie Rosmerski for the people.
Yes, Your Honor. Brandon Bird on behalf of Deborah Gilmore. Ms. Gilmore, can you please state your full name for the record?
Deborah Gilmore.
All
Morning, Your Honor. People are unable to proceed at this point.
right.
Respectfully request dismissal, Your Honor.
Your Honor, request a remand for this meeting.
All right. People being unable to proceed as to count 1, that is dismissed. I'll maintain the not guilty plea as to count 2. I'll set that for a pretrial on
June 9th at 9 a.m. before Judge Washington.
June 9th, 2025, 9 a.m.
Yes.
9 a.m. before Judge Washington.
Thank you, Judge.
Thank you, Bond. Go continue. Thank you. Okay. Court does call the case, People versus Brandon G.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Ben Dunawith on behalf of Mr. Gevers, who is standing to my right. Brandon, would you state your name for the record, please?
Brandon Gevers.
Your Honor. Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that here. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we will waive the formal reading and stand mute.
Defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for July 17, 2025, 1:30. Judge Slay.
Your Honor, could I address Ron briefly?
He's out.
He's out, but he's on a tether, and the complaining witness apparently lives thousands of miles away. So I don't think the tether serves any purpose, and we'd ask the court to take it off.
Your Honor, I just have concerns given the facts of this case. I'll leave it in the court's discretion, but I just have concerns given the highly valued factors in this case of strangulation. But she does reside out of state, Your Honor.
They're not in any proximity to each other.
No.
It's just a GPS location track.
I would ask the court, if we don't leave the tether on until tomorrow, she is in state today. So I would have concerns for her safety while she's here, and would ask that the tether be moved when she's back out of state.
His bond will continue. What I will do is I send an order. We'll remove the GPS.
A nuanced compromise here. The defense argues the tether is pointless since the witness is out of state. The prosecution counters she's still here for now. The judge finds middle ground, tether stays until the witness departs. Smart move? Overkill? Balancing protection and freedom is a legal tightrope.
On behalf of Mr. Brandon Carter, it has been discovered that Mr. Carter has been lodged at the Monroe County Jail.
Oh.
But he is unable to make this court date. He'd love to, but
So he's currently lodged there?
that is my understanding.
Is that also the people's understanding?
My officer in charge.
Okay, so do we know how long he will be there?
No, I do not have that information as of yet, Your Honor.
We don't. Well, why don't I do this then? I'll find good cause adjourned.
Final twist, Brandon Carter is missing from court because he's in Monroe County Jail. No one knows for how long. It's a sobering reminder of how fragmented the system can be. One defendant, two jurisdictions, and a whole lot of delay. Justice doesn't pause, but sometimes it stalls. Should courts be more connected across counties?
And this is all messed up. What? Oh, I can't. You're right.
Correct. You have the 17th in the afternoon.
I have the 17th of,
Yes, of June, because of Juneteenth. So it's PMs.
oh,
So you ain't got a date?
June 17th, 2025 at 12 noon.
Would the court consider just a nominal bond in the event if he were to be released, at least he wouldn't drift off into the ether because he wouldn't necessarily have notice of this date? Obviously, we will work to rid him, but I don't know. He may get out of Monroe County Jail between now and June 17th.
Any response?
A very, very nominal bond, Your Honor. Like $10.
This courtroom session gave us a full spectrum guilty pleas, dismissed charges, denied bonds, and career beginnings. We saw real emotion, raw consequences, and powerful rulings. Whether it was a judge standing firm or a defendant begging for another chance, each moment reminded us how much is at stake in every case. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. This courtroom is about to erupt, so buckle up. Today we're diving into a courtroom roller coaster where bond violations, drug tests, and desperate pleas collide with icy judicial logic. From defendants blaming super-duper cocaine to heartfelt pleas from young fathers trying to stay out of jail for the sake of their kids, this hearing has it all. You'll witness a parade of stories, some heartbreaking, others outright unbelievable, unfolding in real time before a no-nonsense judge who doesn't pull punches. We've got a young man claiming he's clean while still testing hot, another begging for a tether to care for his toddlers, and a college student who just wanted DoorDash but ended up in jail. So who gets another chance? Who's sent back to detox behind bars? And how does a medical marijuana card complicate everything? Stay locked in because this isn't just about the law. It's about choices, consequences, and the razor-thin line between redemption and relapse.
I'll just indicate at this point, I don't have a report. I'll set it out basically at 90 days from the date of this report. So hopefully we'll.
Here's our first moment of quiet tension. D'Angelo Simmons' case kicks things off with a competency review, and the courtroom doesn't even have the updated report on hand. That might sound bureaucratic, but in legal terms, it means a delay in determining whether the defendant is mentally fit to even stand trial. Without that green light, the case can't legally proceed. It raises an important question: how often are cases stalled because of missing paperwork or delayed evaluations? Let us know in the comments, do you think courts move fast enough in mental health-related cases?
Call the case People versus Douglas Hill.
On behalf of Mr. Hill. Thank you, Your Honor. I did provide the court with a green sheet. We're simply asking for a brief adjournment in this case.
If I were to test your client, will you test clean today? And I don't like being lied to.
Probably not.
Okay.
What would be in your system?
I've been tested dirty for cocaine and THC.
This moment is wild. Douglas Hill admits on record that he'll likely fail a drug test today, and the judge is not having it. She flat out says, "I don't like being lied to," which sets the tone for the rest of the hearing. And then, the cocaine discussion begins. This is where legal truth meets personal chaos. He's claiming he's trying to clean out, but the judge makes it clear, if you're still using, you're going back. The takeaway here: courts don't operate on grace, they operate on data, levels, test results, cold, hard numbers.
Appointment for Monday at 9:30 with the brown guy for the outpatient program.
Yeah.
Yes, because I thought I showed up at 2, it was at 1:30, and then I also dropped yesterday.
Why is cocaine still in your system?
It will not be today.
Well, you just told me it was gonna come back.
Because I haven't dropped clean yet, that's why I assumed that. I don't know how long it takes to leave.
You're still using.
No, I'm not.
No, because you want, okay, I'm gonna tell you what, if you're telling me you're not, I'm gonna take you back. I'll call over, get levels, and then we'll see exactly what's happening.
So I
You
gotta,
want me to do that?
so I can drop today?
No,
I'm sorry, I
you
didn't.
would go back there with my bailiff. I will call over and get levels. If you're telling me that your system is just cleaning out.
My system should be clean.
No, that's not what I'm saying. You're telling me you're not using,
Correct.
right?
Yes.
Okay. Then this must be some super duper cocaine.
I have.
So we'll figure it out. And so what I'm gonna do is, Mr. Allen, you can take him back. We will call over to community corrections, get your levels, and then we'll figure out what's happening. Court does call the case, People versus Romeo Serba. Oh, 2 in a row.
Kevin Addition on behalf of Mr. Serval, who is approaching.
Your name, sir?
Romeo Serval.
Thank you.
Your Honor, we are going to be asking for an adjournment for mitigation, and we would like to address bond, please.
Probable cause conference will be adjourned June. May 29th, 2025, 9 a.m. I need a green sheet and then that's bond.
As to bond, Your Honor, I wanted to address, I wanted to ask for him to be released on tether. Your Honor, Mr. Servo is 20 years old. He has 2 children that he takes sole custody of. He has to take care of them right now. They're in the care of his.
This moment is wild. Douglas Hill admits on record that he'll likely fail a drug test today and the judge is not having it. She flat out says, "I don't like being lied to," which sets the tone for the rest of the hearing. And then, the cocaine discussion begins. This is where legal truth meets personal chaos. He's claiming he's trying to clean out, but the judge makes it clear, if you're still using, you're going back. The takeaway here: courts don't operate on grace, they operate on data, levels, test results, cold, hard numbers. This is one of the most emotionally gripping moments in the video. Romeo Serba's attorney lays it out: 2 kids, sole custody, 4.0 GPA, and a young father juggling work, school, and sobriety. He's begging to be placed on a tether just so he can go home and be a parent. It's a vulnerable appeal that shows how the justice system collides with real-life hardship. But even then, the judge's concern isn't just about empathy, it's about compliance, history, and reliability. So here's the question: would you have granted Serba a second chance? Or is his record too much of a risk?
But his April 24th report from community corrections.
I'm not in receipt of that. The last one I have is as of April 23rd. I may have missed it, but
April.
the report that I have, the last test on there that was missed was the 23rd of April. Let me look.
Right, but there should be a bond violation report from that's dated April 24th, 2025.
Oh, this is the one. Oh, no, sorry. Yeah, April 24th. This is the same one I'm looking at.
Okay.
Okay.
Go ahead.
Yes. As 2 of those were missed when he was in custody elsewhere. 4 of those he missed, but he retested like within 20 minutes, 15 minutes, 7 minutes after.
This moment is wild. Douglas Hill admits on record that he'll likely fail a drug test today and the judge is not having it. She flat out says, "I don't like being lied to," which sets the tone for the rest of the hearing. And then, the cocaine discussion begins. This is where legal truth meets personal chaos. He's claiming he's trying to clean out, but the judge makes it clear, if you're still using, you're going back. The takeaway here: courts don't operate on grace, they operate on data, levels, test results, cold, hard numbers. Here's where legal nuance gets sticky. Serba's lawyer makes an interesting argument. Yes, there were missed tests, but he retested within minutes, sometimes just outside the allowed window. Should that count as compliance? The state says no, and the judge seems skeptical. But from a public perspective, this is one of those gray areas where intent and technicality clash. The legal system is rigid, but life, especially with kids, school, and trauma, is messy. So where do we draw the line?
24. So it would have been while he's on court supervision, Oakland County Circuit Court on a similar charge that also falls with the defendant's ability to come.
Your Honor, he is undergoing mitigation for mental health concerns that we're going to provide to prosecution. I've talked to his attorney in his Oakland County cases. He is on probation for those. He's testing in so many different places for so many different things. That's why also he is having trouble keeping track of these tests. And I mean, again, I believe a tether would help with all, huh? What do you want to say?
I just want to tell him that I did ask when I realized it was gonna be a problem. Based on it, so I won't have any problems with it.
Yeah. He's saying that he requested, well, he wanted a tether in the first place, and
When you're saying a tether, you're talking a scram tether?
Yes, sir. And if I was to get that, I wouldn't have any problems. You wouldn't hear it from me. I don't drink alcohol. There's no alcohol in my household. It's just two children.
This moment is wild. Douglas Hill admits on record that he'll likely fail a drug test today and the judge is not having it. She flat out says, "I don't like being lied to," which sets the tone for the rest of the hearing. And then, the cocaine discussion begins. This is where legal truth meets personal chaos. He's claiming he's trying to clean out, but the judge makes it clear, if you're still using, you're going back. The takeaway here: courts don't operate on grace, they operate on data, levels, test results, cold, hard numbers. Now this is the kind of contradiction that makes you shake your head. Serba says he has a medical marijuana card, claims he offered it to community corrections. They refused to take it. Meanwhile, community corrections says they lost it. And now everyone's pointing fingers over a literal piece of paper. In a system built on documentation, losing track of someone's legal proof of eligibility can mean the difference between jail and release. What's your take? Do you think marijuana laws are being fairly applied in probation settings?
Thank you.
Court does recall the case, People versus Hill. Well,
Yes, Your Honor, we did receive the results in this matter and I have discussed them with my client. And what the likely outcome will be based on that result.
Pardon?
And what the likely outcome will be based on that result.
Well, just so the record's clear, he had indicated to me that he hadn't taken it, hadn't been using, but his levels started out in May of cocaine, started out on May 7th at 424, then went down by May 9th to 353, but then by the 14th shot up to 889.
This moment is wild. Douglas Hill admits on record that he'll likely fail a drug test today and the judge is not having it. She flat out says, "I don't like being lied to," which sets the tone for the rest of the hearing. And then, the cocaine discussion begins. This is where legal truth meets personal chaos. He's claiming he's trying to clean out, but the judge makes it clear, if you're still using, you're going back. The takeaway here: courts don't operate on grace, they operate on data, levels, test results, cold, hard numbers. Let's talk numbers, and they don't lie. This defendant's cocaine levels start high, dip slightly, then skyrocket to 889. That kind of spike is undeniable. The judge catches him in the lie, plain and simple. This is courtroom drama at its most raw, the gap between what a person says and what the toxicology screen proves. And what's the outcome? Bond revoked. Game over for now. Should defendants be immediately detained for these spikes, or do they deserve another shot at rehab before jail?
I'd ask the court to excuse their presence and adjourn this matter.
Well, I'll need some documentation, but Mr. Getty, but I'll adjourn this over to the 22nd, 1 week out.
Thank you, Judge. I will,
2025, 9 a.m.
thank you. I will provide the discharge paperwork when I get it. Thank you.
Court calls the case of the People versus.
This moment is wild. Douglas Hill admits on record that he'll likely fail a drug test today and the judge is not having it. She flat out says, "I don't like being lied to," which sets the tone for the rest of the hearing. And then, the cocaine discussion begins. This is where legal truth meets personal chaos. He's claiming he's trying to clean out, but the judge makes it clear, if you're still using, you're going back. The takeaway here: courts don't operate on grace, they operate on data, levels, test results, cold, hard numbers. Lynette Skinner's case might seem quiet, but it's legally significant. The court is setting a preliminary exam, which is a major procedural step. Plus, they clarify that both cases against Skinner will move forward together. And pay attention to the bond: $1,000 cash on both charges, 10% allowed. That's a specific financial structure, and if you don't post it, you're sitting in jail until your next court date. Small amounts for some, but impossible hurdles for others. How do you feel about cash bonds, fair system, or financial trap?
1,000 cash surety on the case ending in 5724. And on the other matter, same thing. 10%.
Both at 10%, Your Honor.
Hmm?
Both at 10% allowed.
It is cash surety 10%.
Okay, all right. Thank you very much, Your Honor.
Court calls the case People versus Joel Stevens.
And with that, on behalf of Mr. Joel Stevens, who is approaching.
Joel Stevens.
All right.
Your Honor, we are going to be setting this for preliminary examination, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 27th. Preliminary examination, May 27th, 2025, 9 a.m. That's before Judge
Washington.
Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Court does call the case People versus Davian Thomas.
We're ready in that matter, Your Honor.
Andrew Childers appearing on behalf of people.
Lauren Brown, Deputy Chief Public Defender. They're appearing with and on behalf of Mr. Davion Thomas. Mr. Thomas, could you state your name for the record?
Davion Thomas.
We're doing the plea.
Yes, please.
The plea form indicates a defendant will be pleading guilty to an added count 3 of larceny by false pretenses, 200 to 1,000 to 1 year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed, and it is okay for him to seek hideout of the case. That's the agreement of the parties as the court understands it.
That is our understanding, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Davion Thomas, Your Honor.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny by false pretenses, $200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 14A2 court. Do you understand that?
Yes, Your Honor.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes.
Yes. And to that charge, how do you plead?
Guilty, Your Honor.
You understand that by pleading, you will not have a trial? Okay.
Yes, Your Honor.
Did you sign an advice of rights form?
Yes, Your Honor.
All right. Approach. Yes. You signed an advice of rights form. Do you have any question regarding those rights?
No, Your Honor.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you?
This moment is wild. Douglas Hill admits on record that he'll likely fail a drug test today and the judge is not having it. She flat out says, "I don't like being lied to," which sets the tone for the rest of the hearing. And then, the cocaine discussion begins. This is where legal truth meets personal chaos. He's claiming he's trying to clean out, but the judge makes it clear, if you're still using, you're going back. The takeaway here: courts don't operate on grace, they operate on data, levels, test results, cold, hard numbers. Davion Thomas is pleading guilty to a charge that could cost him a year in jail or more depending on the financial restitution involved. But what stands out here, he used someone else's card for DoorDash. That's $40 that could now cost him his future. And the judge makes it very clear, this plea waives his rights to trial and appeal. So even if the amount seems small, the consequences are massive. Comment below, do you think first-time non-violent offenders should face jail time for petty theft like this? Or is there a better solution?
So you did that. And in using these cards, the value of the property that you received, was that in excess of $200?
No, Your Honor. It was.
Your Honor, I'd be asking the court to take the plea.
To a higher charge for the house. All right, and the court can do that. And you didn't have anybody's permission to be using these cards?
Correct, Your Honor.
All right. All right. Counsel, have I complied with the court rule?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be May 28, 2025, 10 a.m. before Judge Bar.
Your Honor, may I address the issue of bond?
Go ahead. Everybody else has.
Your Honor, my client has, originally, he was not incarcerated. The court put him on, I believe he missed the court date. I think he had taken a trip, a family trip. He
What?
had taken a family trip. He was able to do that, but he wasn't able to make it into the next court date. I believe that's how the case went.
This moment is wild. Douglas Hill admits on record that he'll likely fail a drug test today and the judge is not having it. She flat out says, "I don't like being lied to," which sets the tone for the rest of the hearing. And then, the cocaine discussion begins. This is where legal truth meets personal chaos. He's claiming he's trying to clean out, but the judge makes it clear, if you're still using, you're going back. The takeaway here: courts don't operate on grace, they operate on data, levels, test results, cold, hard numbers. This is a moment of hope. Thomas's lawyer makes a compelling plea. Let the young man out. He's about to start classes at Macomb Community College. The judge wants assurance he'll come back. And guess what? Thomas did the right thing. He turned himself in. That carries serious weight in a courtroom. This becomes a powerful moment about responsibility and second chances. The judge sees the sincerity and grants a $25,000 personal recognizance bond. That means Thomas walks free, if he stays clean and shows up. Did the judge make the right call?
Up now?
Yes, Your Honor.
You ever been in jail before?
No, Your Honor.
So this has been Mr. Brown's right. This has been an experience for you.
Yes, Your Honor.
Meaning you take it serious, right?
Absolutely, Your Honor.
I'll reduce the defendant's bond. I'll set it at $25,000 personal recognizance bond.
Thank you.
Thank you. Court does call the case of the people versus Brendan Williams.
We're ready in this matter, Your Honor. Deputy Chief Public Defender Ping, Whitman on behalf of Mr. Williams.
Your name, sir?
Brendan Williams.
What are we doing?
Your Honor, we are respectfully requesting we're going to set this matter for preliminary examination.
My
client is currently, yes, and right now, well, there's a complication. There's a new case that's arisen. We'd like to be able to resolve these matters, but we have to know what's happening on the new case because that's going to be part of this. So it is complete for this case. We may even resolve this case short of preliminary examination, but we will need to have that other case.
The other case, does it affect this case?
Your Honor, if I can clarify, I thought we were adjourning for that purpose, but Mr. Williams has a high BAC case set for.
This moment is wild. Douglas Hill admits on record that he'll likely fail a drug test today and the judge is not having it. She flat out says, "I don't like being lied to," which sets the tone for the rest of the hearing. And then, the cocaine discussion begins. This is where legal truth meets personal chaos. He's claiming he's trying to clean out, but the judge makes it clear, if you're still using, you're going back. The takeaway here: courts don't operate on grace, they operate on data, levels, test results, cold, hard numbers. Brandon Williams has people fighting for him, a supportive aunt, a son, and defense attorneys asking for a tether, but the judge isn't swayed. Why? Because Williams has an upcoming high-back case tied to alcohol and assault allegations. Even without presuming guilt, the pattern raises red flags. This is where bond decisions aren't just about fairness, they're about public safety. The judge denies the modification and makes it clear, until the facts are sorted out, he stays in. Tough, but legally justified.
And have been in the court all day today and waiting for this matter. I've spoken with his aunt. She would be willing to allow him to stay with her during the pendency of this matter.
The case, the new high BAC, what was the offense date of that?
Your Honor, the IBAC offense date is, I have it right here, that was April 3rd of 2025.
Okay, here's my problem. I've got that charge coming up, and I'm not presuming his guilt on that. But I certainly got a high level of alcohol involved in that case. That case is coming up. I've got an indication that there's alcohol involved in this case, plus then assaultive behavior is at least alleged in this case. At this time, and maybe certainly after Judge Freshour hears that her her mind will change on this, but at this time, I'm not gonna reduce the defendant's bond. I'm gonna deny the request for modification of bond and we will continue.
Thank you.
Court recalls the case People versus Scott Jenks.
And then on behalf of the people, Your Honor.
And Stephanie Can on behalf of Mr. Jinks, who is appearing to my right. Mr. Jinks, please state your name for the record.
Scott B. Jenks. Help me.
Did you get it? Okay. Your Honor, I've spoken to my client regarding the possibility of a self-defense argument and his desire potentially go to trial. My client has indicated he does not want to go to trial. He is not exerting a self-defense and he would like to proceed with the plea.
All right. So you're waiving your right to assert a self-defense claim. Is that correct, sir?
Yes, sir.
All right. And so at some point during the altercation with your wife, you, without her permission, put your hands on her and pushed her down. Is that?
Scott Jenks just gave up a self-defense claim and pleaded guilty to assaulting his wife. It's a heavy moment, made heavier by the quiet delivery. The judge makes very sure that Jenks understands what he's giving up, his right to trial and his defense. This plea carries weight not just legally but emotionally, because when domestic violence is on the record, sentencing isn't just about punishment, it's about protection. If you were the judge, how would you sentence this case?
At 10 a.m. with Judge Freshour.
June 5th, 2020.
The plea is accepted and sentencing is set, but what stands out here is how final it feels. In just a few short minutes, Scott Jenks went from preparing for a trial to admitting guilt, and now he awaits sentencing. This is how fast courtroom decisions can change a life. And once it's on the record, it's on the record. There's no going back. What do you think? Was this a plea made in good faith or out of pressure?
Daughter is here. His daughter is here. The family home has been vacated. It's my understanding from her that the complaining witness in this case is now living with the daughter and no longer at the family home, so he can go home.
His daughter?
Yes,
Okay. So, okay, gotcha.
yes. That the complaining witness is no longer living at the family home, so he would have somewhere to go. This is his very first time doing, well, anything. My client will appear for court. He has no desire, nor will he be seeking any contact with the complaining witness in this case, Your Honor. We're asking for a PR bond.
And Your Honor, we have not had direct confirmation from the victim that she has vacated that address. We don't have a new address that she has. However, I would leave it in the court's discretion as to release. If he was to be released, Your Honor, I would ask that he be placed on a GPS tether as well as some type of testing, or alcohol testing or a scram tether.
Do I have an indication of alcohol use in these cases?
Yes, Your Honor.
There is, okay. Well, I won't put him on a GPS because we can track him from the scram tether, quite frankly, but what I'll do is I'll modify his bond. I'll give him $25,000 personal cognizance bond, so I'll release him, but he has to be placed on a scram tether prior to his release.
Thank you, Your Honor.
Thank you. All right, thank you, sir. Court calls the case, People versus Martez Dalton.
Rachel McDuffie for the people.
And Maggie on behalf of Mr. Dalton, who is appearing to my right, Your Honor.
Your name?
Martez Dalton, sir.
I told you he was on the bus. I told you you'd get here, Miss Mackey. They didn't have any faith in you. I had all the faith in the world you were gonna get here.
Your Honor, I want to thank you for passing on the matter, allowing me time to get here, sir, in the time of the matter.
You know what? I had to pass it because she was just screaming at me.
Sir, I don't make no
Miss
excuses.
McDuffie wanted a bench warrant. I had faith in you, and so we gave you time.
Thank you, Your Honor. Thank you, Your Honor. I appreciate that. I was coming. I wasn't finna miss
No,
anything.
I appreciate you going through the effort to get here, sir.
The plea is accepted and sentencing is set, but what stands out here is how final it feels. In just a few short minutes, Scott Jenks went from preparing for a trial to admitting guilt, and now he awaits sentencing. This is how fast courtroom decisions can change a life. And once it's on the record, it's on the record. There's no going back. What do you think? Was this a plea made in good faith or out of pressure?